So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Last month, the regional director of the National Labor Relations Board decided that the men's basketball team out of Dartmouth were employees within the National Labor Relations Act. Subsequent to that, the players out at Dartmouth voted 13 to 2 to go ahead and unionize, and they were working with Service Employees International Union, SEIU, Local 560. And that was a big game-changing decision when they made this decision to consider them employees. And that's been a part of a lot of debate. Back in 2014, a different National Labor Relations Board regional director thought that the Northwestern University football players were actually employees at the time, and that was based on whether or not Northwestern University was kind of controlling the students, right? They had a rigorous practice schedule, mandatory requirements, etc., and as a result, Northwestern was acting as an employer in the context of the National Labor Relations Act. Ultimately, the Obama board changed direction, reversed the ruling, and said no, they don't have jurisdiction back in 2014. And things were, not very active on this regard. But we've got another activist general counsel, Jennifer Abruzzo. She's the general counsel for the National Labor Relations Board, and she's been an activist from day one. I mean, some of her decisions have really changed the game. But in 2021, she did the statutory rights of players at academic institutions. And that was a GC memo, and there she decided, yeah, athletes at academic institutions are actually employees under the National Labor Relations Act. And again, still a really big change. Obviously, the National Labor Relations Act has been in place since 1935, and at no point has the National Labor Relations Board decided that these players were actually employees under the meaning of the act. And this went further with the National College Players Association. They filed an unfair labor practice charge back in 2022 because they said that USC, the USC Trojans, misclassified football and basketball players, saying that they're actually student athletes but not employees. And ultimately, the regional director agreed with the unfair labor practice charge, and that's before an administrative law judge as well. So Dartmouth decided that they're going to unionize. They said, well, Dartmouth's got a lot of control, and it's true. Dartmouth, has a lot of control over its players after its employees. They control when they are supposed to come to quote work. They control how much they make. They control their access to medical and nutritional professionals, where they are supposed to work out, et cetera, et cetera. And so it's very clear. And again, regional director of the National Labor Relations Board agreed with the players, and so they then executed the 13 to 2 vote last month. So it was pretty overwhelming. Again, they're working within this SEIU Local 560. SEIU is a very big sort of umbrella union. They have quite a bit of power within the workplace. I know they're service employees, which it doesn't seem to match, but again, a lot of these umbrella organizations really have a lot of power in a lot of different areas. What's interesting is Dartmouth. Now, Dartmouth is one of the more conservative colleges in the Ivy League. That's not saying much, but 82% of students plan to vote for Joe Biden, according to the Dartmouth Review, which is their newspaper. So the Dartmouth Review, this is an overwhelmingly liberal institution. However, on March 18th, Dartmouth decided that they're not going to bargain with the Services Employees International Union. They're not going to bargain with its what's considered to be employees at this time. It said varsity athletes aren't employees in the Ivy League. They are students whose educational program includes athletics, and as a result, the school is not going to bargain. They disagree with the National Labor Relations Board and Abruzzo, who has been very clear that they are employees. This will ultimately result in an unfair labor practice charge, and the National Labor Relations Board, who is judge, jury, and executioner, and that's part of the problem, right? So there is a lawsuit going on right now that says that National Labor Relations Board obstructs democracy, is antithetical to democracy, because it makes the rules and then enforces them and then judges you based on those rules. In my opinion, All of these things should be going through Congress if businesses are meant to be held to them, right? If they have the penalty of law, and there have been people who have been arrested for violating the National Labor Relations Act. I have a video on that quite a bit back. I'll try to link it down below. But people have been violated or have been arrested as a result of violating the National Labor Relations Act. As a result, they are judge, jury, executioner. And Dartmouth says it's not giving up the fight and it's going to appeal any decision to a federal court. What do you think about this decision for Dartmouth not to bargain with what is currently considered to be their employees? Let me know in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.